Alright. Alright. I can make my bigger. Oh, look at that. Alright, so it's 11:52 here. What day is it? Pretty sure it's Friday. No, it's Saturday. Saturday. June 14th. So, yeah, 11:53. I sent this, or this was sent to me at 11:45. Dear Tasha, this verifies the receipt of one document submitted to Pasco County Criminal. There's my court case. There's my filing number. And what I filed was this. It's probably not perfect because I'm not a lawyer, but it gets the point across. It's a demand to dismiss with prejudice for judicial notice of attorneys, felonies, for sanctions, for formal public apology, for judicial recusal, and for notice of judicial obstructions and fraud in the court. This has all been brought up before. I'll show you the dates, and it just goes ignored. The courts ignore the stuff that I've been talking about since I was sitting at the other park. What, last year or the year before? Talking about this very same stuff that they're trying to sweep under the rug. But I'll just get through it. Those of you that know. If you have questions about this, I made tons of videos about it. It's pretty cut and dry. So pursuant to these stupid rules, comes now me. This is all I do every single day, every single minute of every single day is this. This is all public info. It abides by all terms of service. Doesn't violate any of YouTube's policies. This is informational. It's newsworthy. Doesn't share any information that shouldn't be shared. Just so you know. So comes now me, and I respectfully, how do you respect these people? Move the court to immediately dismiss all charges against the defendant, me, with prejudice. To take judicial notice of felony criminal charges against court-appointed counsel, Pamber Smatwell, a.k.a. Amber Hill, a.k.a. Amber Hambrecht. She's got tons of aliases. Recuse itself, being the judge, for actual bias, willful blindness, and obstruction of justice. Formally acknowledge judicial obstruction under that rule. Refer this matter to Inspector General and U.S. Department of Justice for investigation. Sanction the Office of State Attorney and the Pasco County Sheriff's Office for malicious, retaliatory, and unequal prosecution. These dogs are acting up. And issue a public apology for appointment of a known drug-addicted, criminally charged individual as legal counsel for the defendant. And they should also prosecute her for trafficking illicit substances. So yeah, and issue a public apology for appointment of a known drug-addicted, criminally charged individual as legal counsel of the defendant. And procedural and factual background. The defendant has been prosecuted continuously in this case more than 3 years, with 5 jury trials canceled, multiple attorneys withdrawn, and dozens of court filings ignored, stricken without cause or hearing. The defendant's 8th court-appointed attorney, Pamber Smatwell, was under active criminal investigation during her representation and was subsequently charged with 2 felony counts of child endangerment. One of those charges was dropped, but she was found guilty by a jury of the one remaining charge. 1 felony count of perjury in official proceedings. I don't know what they're doing with that. I'll find out on Monday. An official evidence transfer receipt dated June 5th, 2025 reveals the possession of approximately 20 grams of MDMA, a trafficking quantity under Florida statute. 27 pills of Adderall, Schedule II controlled substance under Florida statute. Surveillance, photographic evidence of injured children, body-worn camera footage, toxicology results, showing controlled substance in her system at the time of an incident. It's unclear whether the 27 Adderall pills found in Ms. Patwell's possession were legally prescribed or illegally obtained. Either scenario is disqualifying. If illegally possessed, this constitutes felony possessions of a Schedule II controlled substance under the statute, and raises further concerns of intent to traffic or distribute, yet no additional charges were filed. If legally prescribed, this indicates a serious underlying mental or neurological condition, which will raise concerns under Florida bar rule regarding the capacity to represent criminal defendants. She's in no way fit to represent anyone. Take care of her kids. She needs to be in prison. Further, it's believed Ms. Papa was under DCF investigation or barred from unsupervised contact with her children due to child endangerment charges. She was deemed incapable of caring for her own children. She could not have been fit to represent others in a courtroom. This reflects gross negligence and a lack of judicial oversight. Moreover, Ms. Patwell's felony perjury charge revealed a pattern of dishonesty. She filed a motion in this very case to have the defendant declared mentally incompetent only after being reported to the Florida bar. This act was retaliatory, without medical basis or client consultation, intended to discredit and silence the defendant. The court granted her motion, thereby compounding the abuse and aiding the concealment of Ms. Patwell's misconduct. During a hearing, the defendant alerted the court that her counsel had 2 felony charges. The court responded dismissively with, "Who, you?" Judge Frank Gray said, "Who, you?" To me. Derisive and evasive remark that evidenced judicial bias, gaslighting, and refusal to acknowledge serious concerns raised on the record, if there's a record around. The judge agreed with her. I have on tape. He said, "Yep, based upon me, and our prior interactions, he agreed with her." Like, you got a felon right here. That come to find out, then she gets perjury charges. Come to find out, she got 20 grams of MDMA. Come to find out, she got 27 Adderall 30s that were somehow all overlooked. Any one of us would be in prison a long time ago, for a very long time. So yeah, a derisive and evasive remark that evidenced judicial bias, gaslighting, and refusal to acknowledge serious concerns raised on the record. This hearing occurred prior to the perjury charge being filed, further confirming that the court took no action even after hearing Patwell was facing multiple felony charges. This is fraud in the court and judicial complicity in criminal misconduct, procedural authority, or legal authority. So here's the 3.190 C4 motion to dismiss as proper. This it talks about undisputed facts. Try to find that's something that's not a C4, where there are no materially disputed facts. I'm not going to get in the minutiae of that. Price for relief from judgment, where there's ineffective assistance of counsel, due process violations, and prosecutorial misconduct. And then this other one requires that prosecution disclose exculpatory and mitigating evidence. So, the other one governs competency proceedings. None of its requirements are met. When the court approved Patwell's motion without proper evidence or notice, where she did that, it was just a pretrial hearing, and she turned it into something completely different. And then the judge tried to turn it into a Nelson or a Ferretta hearing, but he couldn't do both at the same time. This is whacked out. There is not a shred of justice or semblance of justice here. So then the judicial administration requires judicial recusal upon showing of prejudice or bias. And you can pause this and read it. So yeah, arguments. The appointment of felonious counsel was a fundamental violation of due process. And this court gives a crap about due process. They won't give me an attorney. They won't give me a trial. They won't give me remote appearances. They won't give me ADA accommodations. None of that. Ms. Patwell's appointment while under the active felony investigation and possession of illegal narcotics constitutes ineffective assistance of counsel. Gideon versus Rainwright, they don't care about that. Strickland versus Washington, they don't care about that. State and court knowingly assign an unfit, impaired, and criminally compromised attorney to a vulnerable indigent defendant, which being me. Judicial obstruction and misconduct, demand recusal and referral. I've already asked him to recuse himself once already. Oh, that's denied. I'm going to stay on this case. We're going to help out the felons. We're going to help the felons help me get you into jail. And the court's dismissive action on record disclosures. It's not a court record. Failure to act on attorney, felony charges, and approval of retaliatory mental health motions constitute judicial obstruction and bias. Recusal is not only warranted, it's but required under judicial ethics and due process standards. How many of these judges I'm gonna catch? Don't even have to catch them; they just do it. Whatever, they're violating judicial canon all the time. And it's not just me; it's happening too. States and sheriff's office engaged in retaliatory and unequal protection while ignoring a drug trafficking and child endangering attorney. The state maliciously pursued charges against a defendant, a disabled homeless victim with a substantiated evidence. This constitutes unequal treatment and selective enforcement, violating equal protection clause and fundamental fairness. And I posted a couple weeks back about a trial where the lawyers are saying, "Oh, we don't want her evidence of drug abuse to be shown to the jury, like her toxicology reports." But they totally omitted that this woman had trafficking levels amounts in her house in front of kids. This was a drug house. So the jury didn't get to find out about that. They all knew about it. Sheriff knew about it. Should have been charged with that too. Should never get her kids back, ever. And she conspired with her sister to adopt these kids out. These kids should be stripped from her sister too. Her sister's just as guilty. So relief requested. It's demanded. So wherefore I respectfully, I don't respectfully do any of these people. I do not respect them. Immediate dismissal, demands immediate dismissal of all charges with prejudice. Judicial notice of Amber Pat was felony charges, the drug and child endangerment evidence against her, her perjury conviction, retaliatory conduct in this case, judicial recusal for demonstrated bias and misconduct, public apology, formal public apology, acknowledging the appointment of criminally compromised and mentally unfit attorney, referral to the court, state attorney and sheriff's office to the Department of Justice and our Florida Inspector General for Civil Rights and Criminal Investigation. These tough-on-crime cops are going to overlook 20 grams and 27 pills. Were they her pills? Did she buy them off somebody in the street? Did she get them from her ecstasy dealer? Was she selling them? You know she's taking them. It was all in her system. Put proof up here. Sanctions against the Office of State Attorney, Pasco Sheriff's Office. So here's the exhibits. Evidence transfer receipt. Exhibit A. Exhibit B, docket of Amber Patwell's criminal case. Exhibit C, defendant's prior filings regarding Patwell's misconduct and motion to sanction. Exhibit D, Amber Patwell's motion to withdraw on record of her filing for competency evaluation. Respectfully submitting my certificate of service. Here's Exhibit A. Here's the evidence receipt. Got thumb drive, body-worn camera, Deputy Reed, composite photos of Adderall located in kitchen. See, all these drugs are in the kitchen. Kids can reach up there and grab the Adderall. Can grab the MDMA. Eat it like candy. But they're too busy being beaten upstairs. This person needs to be in prison forever. Adderall tablets, 27 count, 30 milligram DP30. Were they loose tablets? One loose tablet and you're screwed. It's not a properly labeled prescription bottle. Who's labeling this evidence? MDMA, total package weight, 20 grams. 6 8-balls. As far as I know, 1 8-ball. You, a friend, and a third party to go clubbing on a Friday night. Go dance and look at the pretty lights. And come home and then never do it again for another year. If you dabble in that stuff. Wise camera, thumb drive. I want to get the evidence for this too. This should be public record because it's part of a court case. She pissed on herself, puked on herself. Had a head injury. She has post-concussive disorder, going to mental health counseling, and she's defending me? She's in jail before me and in jail the same time I am? Photo of victim. Of something on stairs. Thumb drive. Composite photos, stairwell and loft area. Composite photos of child victim in the bedroom. Composite photos of defendant. Composite photos of child victim with injuries. I think that's what that is. Composite photo of cell phone found in house. Composite photo of money and drugs located in kitchen. Your kids go to get a cookie out of the cookie jar. There's money and drugs in the kitchen. Grand Theft Auto, 6th Judicial Circuit. So I put Exhibit B, Amber Patwell's criminal cases. So we got a felony. Perjury, making false affidavit in official proceedings. She's a liar. Much like my trustee. Child neglect, without great bodily harm. But the evidence says there's great bodily harm to at least one of the kids. 2 counts. Convicted of 1. Sentencing comes Monday. She's not going to be charged for the drug possession. I can't stress this up. Trafficking-level drug possession with intent to distribute with kids. You're an officer of the court. Exhibit C, motion of sanction. I put that in 9/22/24. They ignored it. Misconduct by attorneys. You can pause this and read it. Marie Mabry, Jacinia Rosales, Amber Patwell. Ms. Patwell filed for a mental health examination retaliation for my filing of a bar complaint against her due to negligence and erratic behavior, despite my informing the court that she was facing felony charges including perjury and child neglect and had a history of drug and alcohol addiction as well as mental health problems. Her withdrawal was granted without prior scrutiny. Her filing for a mental health evaluation was a clear act of retaliation meant to discredit me and delay my case further, while avoiding accountability for her own misconduct. She only answered my initial phone call and sent every subsequent call to a voicemail that was not set up. With the remainder of representation, it only caused me injury and whatever. But I was just putting that in there. And I can't put a whole PDF in there. I'm not that technically inclined. I'm a disabled person. And then Amber withdrawal, 1/19/2024. So I complain about her, although it was 8 months later. But I complained about her to the court, to that guy's face. So she talks about, she said, where is it here? This case was set for Nelson Ferret hearing on February 2nd. No, it wasn't. They changed that. Court has entered a competency evaluation due to be done on the defendant, and the undersigned has prepared an order on the same that's sent to the state's attorney's office and will be sent to proposed order to Judge Gray. And they blocked it. I have the hard copies. I'm just overwhelmed. She filed for a competency evaluation and labeled it Pinellas County, and we're in Pasco. She's off her rocker, drunk, stoned out of her mind, eyeballs fluttering, Adderalled out. But you can read that. She makes up all sorts of lies. Said, stated in open court, the undersigned attorney filed a motion for competency evaluation as retaliation because the defendant filed a bar complaint. The undersigned had not received any bar complaint from the defendant. The defendant then threatened to make bar complaints against the undersigned. And that's where the attorneys say that I was threatening them. Yes, with bar complaints. Because they're crazy. They're absolute mafia-level criminals. The defendant was visibly upset when the undersigned attorney in court, speaking very loudly and interrupting the court. This is a felon. This is a felon. Listen to me. This person's not representing you. But anyway, I'm going to leave it at that. What do you think of this? This is earth-shattering stuff right here. People are being screwed over every day. People are getting their lives ruined. Where these people aren't even getting charged. And they're helping put innocent people in jail. And the courts are totally complicit. Thanks for coming. And I need your help. I need your help. Call so-called good attorneys if they're already. Contact the governor's office. Contact lamestream media. This should be in every paper. Nationally.